Hi everyone. Today we'll be looking at learning outcome for and the unit we're doing is English legal system, and my name is Shazia Khan. Learning outcome 4 is to look at understanding the operation of judicial precedent. Just a summary of what we did in the last few sessions. So learning outcome 1, we looked at the process of passing a law, so from a bill to becoming a law. We looked at the process for the House of Lords and the House of Commons. We also looked at the civil and criminal difference between both. We looked at private and public. Then we went on to looking at learning outcome 2, which is we looked at statutory interpretation, and we looked at the rules of statutory interpretation, such as mischief, golden, literal, and the judge's discretion, the importance of this when making a decision, because it's so important in regards to trying to come to a fair decision for the person. So we also looked at things like intrinsic and extrinsic aids that help the judges make the decisions, such as Hansard or previous cases, any sort of issues around previous precedent. We then went on to learning outcome 3 when we looked at the court structure. So we looked at the criminal court structure and the civil court structure with reference to the courts such as Supreme Court being the highest court within the UK. We also looked at the Court of Appeal. We looked at the High Court and its divisions. We did it like Family, Chancery division. We also looked at the personnel that worked within the courts, with each of these courts, and who is bound by these courts and the right of appeal. And we looked at the hierarchy of the court system and why there was a need for the court system. Now we're going to look at understanding learning outcome 4, which is to understand the operation of judicial precedent. So the learning outcomes are to look at how the rules of stare decisis, ratio decidendi, and obiter dicta are used. We're also going to look at distinguishing between distinguishing, reversing, binding, and overruling, and giving examples how they've been used in specific cases. We're also going to look at describing how courts are bound by each other with reference to the Young with Bristol Aeroplane Company Limited case 1944, and explain the impact of res judicata. So 4.1, explain how the rules of stare decisis, ratio decidendi, and obiter dicta are used. Firstly, we need to identify the principle of judicial precedent, which actually means that court must follow and apply the law as set out in decisions of higher courts in previous cases. And an example of judicial review is, for example, if the judge dislikes an individual who dyes their hair, an example, red in colour, he might resist to give the individual a fair treatment, and this can influence the outcome of the whole case. Thus, High Court must follow the decisions that are made by the Court of Appeal. And the reason judicial precedent is so important within the UK, because it provides certainty in law, as cases with sufficiently similar material facts are bound by past decision, and it provides an idea of how cases can be decided. And it also provides fairness and consistency as well. So it's really important that it's used properly. So we're going to now look at the principle of stare decisis. So this is a Latin term that means to stand by things decided. The principle that a court should follow precedent established by previously decided cases with similar facts and issues to provide certainty and consistency in the administration of justice. Generally, there are 2 types of precedent. Binding precedent, precedent that a court must abide by in its adjudication of a case. For example, a lower court is bound by a decision of a higher court in the same jurisdiction. even if the lower court judge disagrees with the reasoning or the outcome of that decision, and persuasive precedent. This is where court is not required to rely on decided cases. Example of persuasive precedent include decisions from courts in neighbouring jurisdictions, and dicta in a decision by a higher court. Then we've got ratio decidendi, and this is a Latin term that means rationale for the decision. The ratio decidendi of a case is the principle of law on which a decision is based. So when a judge delivers judgment in a case, he outlines the facts which he finds have been proved on evidence. Then he applies the law to those facts and arrives at a decision for which he gives the ratio decidendi. The ratio decidendi is essentially the reason why the courts reached a particular decision. So how to find ratio decidendi is look at your subject outline, reading list or case list, take a peek at the object, at the topic headings, cases and journal articles listed above and below the case you're about to read. Doing this before you start reading the case will help to provide some context for your search for the ratio and help you avoid getting sidetracked by all the obiter. Read the head note. When you start reading the judgment, begin with the head note. This will highlight the key issues or legal principles considered by the case. How to find ratio decidendi. Read the whole case. The ratio normally appears towards the end of a judgment, but unfortunately you can't just skip to the end. In its most basic format, a judgment starts by outlining the facts of the case before considering the legal arguments presented to the court and then making the decision. The court's analysis of legal argument is also essential reading, although the ratio will probably be located at the end of the legal analysis, just before the court makes its findings that the defendant is guilty or the defendant was negligent, etc. Focus on the key facts and arguments. So focus your attention on the precedents or legal principles the court discusses at length and the facts of the case that judges emphasize. How to find ratio decidendi. The aha moment. The ratio is essentially the reason why the court reached a particular decision, and that's what I mentioned earlier on. The outcome of the case, therefore, depends on the ratio decidendi. So if you read something that makes you think you know which party is going to win or lose, you may be in a ratio territory. Dealing with multiple judgments. If there is a High Court decision where some of the judges have written a separate opinion, the ratio won't be in the descending judgment. Instead, look for the ratio in the majority decision. If many of the judges agreed or were close enough in their view of the key legal principles, you may be able to distill a ratio, or at least a sort of ratio if there were some small differences in opinion. If the majority agrees on the outcome of the case, but took completely different views of the law to get there, you might not be able to find a ratio. How to find the ratio. Don't panic if you can't find the ratio. If you can't find the ratio, look the case up in your textbook, casebook, or lecture slides. There's a very good chance that the ratio decidendi will be explained, if not actually quoted in the case summary. So it's really important that you don't panic, but you read the case summary or if it's not quoted, then it may be like stated in the case summary, but it will be there. Even if you think you've found the ratio extender, this can be a good way to confirm that your approach is working. Now we're going to look at obiter dictum. It refers to a judge's comments or observations in passing on a matter arising in a case before him which does not require a decision. Obiter dictum remarks are not essential to a decision and do not create binding precedent. However, obiter remarks of senior judges, for example, may be indirectly instructive or persuasive, especially in areas which the law is developing. As we mentioned, the courts are not bound to follow comments made obiter in earlier rulings, but they are very useful when judges are considering cases. An example of obiter dicta is if a court dismisses a case due to the lack of jurisdiction and offers opinions on the merits of a case, then these opinions constitute obiter dicta. Use of obiter dicta. In reaching decisions, courts sometimes quote passages of obiter dicta found in the text of the opinions from prior cases with or without acknowledging the quoted passages stated as obiter dicta. A quoted passage of obiter dicta may become part of the holding or ruling in a subsequent case, depending on what the latter court actually decided and how the court treated the principle embodied in the quoted passage. 4.2, now we're going to look at differentiating between distinguishing, reversing, binding, and overruling, giving examples of how they're being used in specific cases. So the first one we're going to look at is distinguishing. Distinguishing is a method which can be used by a judge to avoid following a past decision, which he would have otherwise have to follow. It means that the judge finds the material facts of the case he's deciding are sufficiently different for him to draw a distinction between the present case and the previous precedent. Distinguishing a case on its facts or on the point of law involved is a device used by judges usually in order to avoid the consequences of an early inconvenient decision, which is in strict practice binding on them, as mentioned. What is reasonable, distinguishable depends on the particular cases and the particular court. Some judges, being more inclined to distinguish, dislike authorities than others. A case example, another one with the case example here is Belfer and Belfer, 1919, and Merritt and Merritt, 1971. Another example where Lord Reed stated is the case of Jones and Secretary of State for Social Services, 1972, where Lord Reed stated that it is notorious that where an existing decision is disapproved but cannot be overruled, courts tend to distinguish it as an inadequate grounds. I do not think that they act wrongly in doing so. They are adopting the less bad of the only alternatives open to them, but this is bound to lead to uncertainty. And a little bit about the Balfour and Balfour case, 1999. In this case, a husband worked overseas and agreed to send maintenance payments to his wife. At the time of the agreement, the couple were happily married. The relationship later soured and the husband stopped making the payments. The wife actually enforced the agreement, and it was held in the Balfour and Balfour case that the agreement was purely social and domestic agreement, and therefore it was presumed that the parties did not intend to be legally bound. Then in the case of Merritt and Merritt, 1971, here a husband left his wife and went to live with another woman. There was £180 left owing on the house, which was jointly owned by the couple. The husband signed an agreement whereby he would pay the wife £40 per month to enable her to meet the mortgage payments, and if she made all the charges in connection with the mortgage until it was paid off, he would transfer his share of the house to her. When the mortgage was fully paid off, she brought an action for a declaration that the house belonged to her. And in this case, it was held that the agreement was binding. The Court of Appeal distinguished the case of Balfour and Balfour on the grounds that the parties were separated. Where spouses have separated, it is generally considered that they do not intend to be bound by their agreements. The written agreement signed was further evidence of an intention to be bound. Now, when you look at the difference between the cases in Balfour and Merritt, they talk about the intention to create legal relations, whereas in Merritt, it was held that the circumstances of the cases were different, because in Balfour and Balfour, the couple were married, whereas in the case, they were separated. So now we're going on to reversing, and this is where the court higher up the hierarchy overturns the decision of a lower court on appeal in the same case. For example, the Court of Appeal may disagree with the legal ruling of the High Court and come to a different view of the law. In this situation, it reverses the decision made by the High Court. So reversing is overturning, as we mentioned, of a higher court. The appeal court will then maybe substitute its own decision. Then we've got the element of binding. A binding precedent is a decided case which a court must follow by law. A case is only binding if the principle involved is the same and the facts of the case are the same. A latter court can circumvent an inconvenient precedent which would otherwise be binding by distinguishing it on the facts or on the legal principle involved. Binding precedents arise from important, as I've mentioned, previous cases, and bind future judges must follow the precedent. However, binding precedent will only apply where the facts of the case are sufficiently similar, as mentioned. However, a binding precedent can be overturned or departed from, for instance, if there's a change in the law or even a societal norms. This means that the previous ruling is no longer good law, and only a higher court can depart from binding precedent. Precedents can be binding, that is, it must be followed in letter cases, or merely persuasive, where it may or may not be used to influence letter cases, as judges are not bound by them. To determine if a precedent is binding or persuasive, the judge would have to consider these main factors. The material facts of the case. In order for a precedent to be binding on a judge in a latter case, the material fact of the two cases must be similar. The hierarchy of the courts. So the higher up the court is in the court structure, the greater their ability to form a binding decision on the lower courts, and the ratio decidendi and obiter dicta, as we discussed earlier. Overruling. So overruling is where a court in a latter case states that the legal rule decided in an earlier case is wrong. Overruling may occur when a higher court overrules a decision made in an earlier case by a lower court. For example, the Supreme Court overruling a decision of the Court of Appeal, or when the House of Lords used its power under the practice statement to overrule a past decision of its own. And the cases in regards to that is the case of Pepper and Hart, 1993, and the case of which overruled the decision in Davies and Johnson, 1979. So 4.3, describe how courts are bound by each other with reference to Young versus Bristol Aeroplane Company Limited, 1944, to A11 ER 293. The Young and Bristol Company, 1944. So Young and Bristol Aeroplane Company Limited, 1944, was an English court case that established that the Court of Appeal is bound to follow its own jurisdiction and those of courts of coordinate jurisdiction, except in the following cases. The court is entitled and bound to decide which of the two previous conflicting decisions of its own it will follow. The court is bound to refuse to follow a decision of its own which cannot stand with the decision of the House of Lords. And the court is not bound to follow a decision of its own if the decision was given per curiam, where a statute or rule having statutory effect of the earlier case was not brought to the attention of the earlier court. In this case, the Young and Bristol Aeroplane, the Court of Appeal decided that it need not be bound by its own previous decisions if at least one of the following criteria was met, one of the three following criteria which I've just mentioned. This case was about a claimant and he was injured and received compensation. He then sought to recover again, alleging breach of statutory duty by his employers. He was employed at the defendant's workshops, received injury in an accident arising out and in the course of his employment and received compensation under the Workmen's Compensation Acts. He then sought to obtain damages in respect of the same accident, alleging that the defendants, in breach of their statutory duty, had failed to fence one of their machines which he was using. In the defence, the defendants pleaded. In the further alternative, the defendants say that the plaintiff, before the commencement of this action, and claimed and received compensation in the Workmen's Compensation Act in respect of the accident, the plaintiff is thereby barred from recovering damages in respect of the said accident, and this plea was based on Section 29, subsection 1 of the Workmen's Compensation Act. On the authority of decision, the Court of Appeal in Perkins and Hughes Stevenson's 1940, the Commissioner gave effect to the plea in the favour of the defendants and the plaintiff appealed. So the court is entitled and bound to decide which of the two conflicting decisions of its own will follow. So it's really important in regards to that these three, the courts decided these elements that need to be followed. 4.4, explain the impact of res judicata. So definition. Res judicata is a decision pronounced by a judicial tribunal having jurisdiction over the cause and the parties that disposes once and for the matter so decided that except on appeal it cannot be relitigated between the parties or their previous. And this is from the Spencer, Bauer and Hadley 2009 4th edition, res judicata. Res judicata is a decision given by a judge or tribunal with jurisdiction over the cause of action and the parties which disposes with finality. The thrust of the doctrine is to prevent a party from relitigating an issue or a defence which has already been determined, known as a cause of action estoppel or an issue estoppel, or which could have previously been litigated. The latter previously principle has been established in the case of Henderson and Henderson and ensured as a matter of important public policy, the finality of the judgment so as to prevent the waste of judicial resources on repeated hearings of the same issues. The res judicata, the principles in the Virgin Atlantic Airways Limited and Zodiac Seats UK Limited 2013 case, Lord Sumption identified the 6 principles which make up the doctrine. So the first one, a party is prevented from bringing subsequent proceedings to challenge an outcome that has already been decided. A cause of action estoppel. Secondly, that if a claimant succeeds in the first action and does not appeal the outcome, he may not bring a subsequent action on the same cause of action. For example, to recover further damages. Thirdly, the doctrine of merger treats a cause of action as having been extinguished once judgment has been provided, and accordingly, the claimant's only right is the judgment itself. Fourthly, a party may not bring subsequent proceedings on an issue that has already been determined, and that's the issue of estoppel. Fifthly, a party may not bring subsequent proceedings which should and could have been dealt with in earlier proceedings. The Henderson and Henderson principle. And there is a general, number 6, there's a general sixthly, there is a general principle, procedural rule against abusive proceedings. The rule in the Henderson and Henderson principle is a well-known established procedural rule that advances principle of finality, as mentioned earlier in the litigation. And as originally pronounced by Sir James Wigram, the rule requires all parties to bring their whole case to the court in a single set of proceedings. So these are the 6 principles that were adopted in regards to the Virgin Atlantic Airways Limited and Zodiac case, 2013. So we've finished the session now, and these are some of the references that have been used for Learning Outcome 4, which is the review of economic dynamics, UK public law and European law, Hart Publishing, Principles of Criminal Law, Oxford University Press, Marshall G. Preston in the United Kingdom in Interpreting Precedents, The Rule of Law by Bingham, 2011, Derbyshire P. Penny Derbyshire, English Legal System, Pearson, Elliott and Quinn. Some more on res judicata, on LexisNexis that you need to refer to if you need to look at any cases. Hart and Green, 2012, The Concept of Law, Oxford University Press, The Rules of Judicata, Effects of Foreign Judgments, Criminal Law and its Processes, Cases and Materials, and also Key Cases, English Legal System by Martin J. And the idea of private law and the English legal system. So these are the references used to complete Learning Outcome 4. There are additional reading and additional cases on Moodle that you need to go on to read around the issue in regards to judicial precedent, and also the elements such as obiter dicta, stare decisis, and the importance of judicial precedent in regards to English law, why it's important in regards to, as mentioned earlier, that the main advantage of judicial precedent, in conclusion, is that it provides certainty in the law, and also if cases are similar material facts, they are bound by the decision. So it makes it kind of easier for judges to refer to cases. It also provides the idea of how cases will be decided. And the main element of it is that it has, it provides consistency in decision making within the law, and ensures fairness for each individual cases, and using the doctrine of judicial precedent, it helps to come to the best decision and the fair decision in regards to making a decision on an individual case. So now we've finished the session, and this was Learning Outcome 4. The next session we'll be doing is Learning Outcome, the the assignment discussion session, which is the next session. So thank you for attending today's session, and I will see you in the next session. Thank you.